Well, the United Nations General Assembly high-level plenary session on addressing large movements of refugees and migrants is now underway in New York. And tomorrow, US President Barack Obama will hold the Leaders' Summit on the Global Refugee Crisis. According to a UNHCR report, there are more than 50 million refugees in the world, the highest number since World War II, and close to 1 million of these refugees and asylum seekers are in South Africa alone. To speak to us on some of the legal challenges facing refugees in the country is attorney Wayne Ncube from Lawyers for Human Rights Litigation Unit. Good afternoon, Wayne. Always a great pleasure to see you on the SABC News Desk.
Thank you very much.
Wayne, what is the legal status of refugees in South Africa today within a human rights context, of course?
Yes, so the status of refugees in South Africa is governed by our Refugees Act and the Constitution, and both those documents provide a lot of protection to refugees, more than you'll find in most countries around the world.
What are some of the major challenges or problems facing refugees in the Southern African region today?
So the biggest problem is really accessing the different rights that they have throughout SADC, including in South Africa, because what the difference is, the practice of actually getting the rights that you do have in law toward is different from how it's actually written. So in most countries, including South Africa, most refugees simply cannot access these refugee services that are provided for. And throughout the Southern African bloc, also movement of refugees is extremely difficult because a lot of countries detain refugees and asylum seekers. Yeah.
South Africa, we have one of the most progressive asylum laws or regime in place. We don't have an encampment policy, and refugees can live and work where they please. But the backlog of refugee applications is still a big hurdle. Why is this? Is this because the process is too lengthy or codified? Is it because it's riddled with administrative problems? You tell us.
So the process is quite simple, the way it is set out in the law. There are two real big problems. The first is with the bodies that are meant to adjudicate the asylum claims. Currently, we have an appeals board, Refugee Appeal Board, which does not have a chairperson, and it has not had one since April. So this has just extended the backlog for a long time. The Standing Committee on Refugee Affairs, which is another adjudication body, also did not have a chairperson for quite a length of time in 2012, and that created backlog. Now, another big problem is refugees access their services at what we call refugee reception offices, and there used to be 5 across the country. But what we've seen in the last 3-4 years is that a lot of these refugee reception offices have been closed. And once you start closing down these reception offices, you only have 2 properly operational reception offices in Messina and Pretoria. And once people just cannot get into the queues and cannot get through the door, they obviously will not have their asylum claims adjudicated. And that creates even further backlog, along with the problems that you have in the adjudication bodies.
Very briefly, Wayne, can you speak to us about migrants who are not genuine refugees, but those who are seeking economic opportunities, trying to somehow regularize their stay in South Africa? What kind of impact has this had on the refugee status determination process?
Yes, so the problem with our Immigration Act, which governs normal refugees, is that it doesn't really take into account the migration patterns throughout Southern Africa, where a lot of the people who are migrating are low-skilled migrants, and they've been doing this for the last 10,000 years. And now what you have is a situation where the only way some of them could have regularized themselves is to enter the asylum process. Luckily, what's happened recently is we've had dispensation permits for some of the countries around South Africa, like the recent Lesotho dispensation permit and the Zimbabwean dispensation permit, which we hope will alleviate some of the strain on the refugee system.
Very quickly, Wayne, let's internationalize this a little bit. The removal of hundreds of thousands of Somali refugees from camps in Kenya, making headlines, raising the eye of human rights activists. What are the international law requirements or standards when it comes to repatriation of this nature?
Yeah, so what we have is a principle of non-refoulement, which is in several of our conventions, including the Convention Against Torture. which basically says you cannot send back a person to a place where they'll suffer persecution. Therefore, a situation like Somalia, where the Dadaab refugee camp has been shut down, it cannot immediately translate to that those people can be sent back to Somalia, particularly when you consider what the country situation in Somalia is with Al-Shabaab. And therefore, what you then happens is you create a humanitarian crisis, because you shut down the only camp that the people can stay in, but under international law, you actually cannot send them back. And a lot of them would be facing death if they're sent back. So there is this situation that the Kenyan government and the whole of Africa has to kind of grapple with.
Wayne Ncube from Lawyers for Human Rights, the Strategic Litigation Unit, joining us on the SABC News Desk. Always a pleasure chatting to you.
Let's move on.